and describe your judicial philosophy, and equally important, describe how you do or would implement this philosophy when deciding cases. And please try to do so without the common cliches as such as the umpire analogy or the I treat each case with an open mind. Try to be as specific as possible to inform our viewers and our audience. Let's begin with Senator Skindell.
Thank you. I am State Senator Mike Skindell. I have been a practicing attorney for 25 years and a state legislator for 10 years, and it gives me some unique experience which I would bring to the Ohio Supreme Court. As we know that a court like a Supreme Court can pull upon the strength of all types of experience. In the United States Supreme Court, of the 111 justices, 40 of them had not served as a trial judge or as a Court of Appeals judge prior to their service on the United States Supreme Court. And we've also had that experience in the Ohio Supreme Court. With regard to generally what I would bring in judicial philosophy to the court, I am a strong believer in our constitutional democracy and our three branches of government. With regard to the judiciary, one of the cornerstones of the judiciary is the doctrine of stare decisis, in which you rely upon past precedents of the court. That doctrine alone gives stability and predictability in our judicial system, and that is something that is essential in implementing our justice system to ensure that the lower courts know how the laws are and what the decisions of the Supreme Court could be, and it also gives guidance to those attorneys that advise their clients with regard to legal matters and how they believe the courts will rule in future cases. Also, I believe strongly that in adhering to the three branches of government, that the judiciary has a role and responsibility of giving deference to the policies and the statutes enacted by the Ohio General Assembly. It is that body, that branch of government, that enacts the policies in this state. Thank you.
And Judge O'Neill, please.
Thank you and good afternoon. My name is Judge Bill O'Neill. I'm retired from the 11th District Court of Appeals, where I served for a decade and some change. I had 2 terms as the presiding judge up there. I have decided over 3,000 cases as a judge. Everything from adoption to zoning, from juvenile shoplifting to aggravated murder. I have sat on the Supreme Court of Ohio by invitation of the late, great Chief Justice Tom Moyer. And more importantly, I have represented clients in multi-million-dollar cases before the Supreme Court, so that my credentials as a former judge and as a lawyer, I don't believe, are open to discussion. There's some really big issues this year in this Supreme Court race. As many of you have heard through the mass media, I'm the judge who refuses to take any money from anybody. I believe that it is fundamentally wrong for a judge to accept contributions from a lawyer or a litigant and then rule on their case. I think it undermines the integrity of the system. I think it tarnishes all who are involved in the process. Recently, I raised my level of discussion a little higher and got specific. In January of this year, First Energy Corporation had, through their subsidiary, Ohio Edison, had a case before the Supreme Court that they argued. 2 weeks later, their political action committee wrote a check for $6,300 to Justice Cupp, $6,300 to Justice O'Donnell, and 4 weeks later, they ruled in their favor. I am not saying that is a crooked decision, but I am saying it is impossible to avoid the appearance of impropriety when you accept money from a litigant and then rule on their case. It's an impossibility. Now, The justices, since I raised that question, have come up with the specter, which I do not believe, that they do not know who gives money to their campaigns. If that is true, they are the first politicians since 1776 who don't know who gave money to their campaign. To clear it up for them, I provided them a spreadsheet this week showing that the First Energy Corporation has given $44,111.12 to the two justices sitting to my left. A week ago, they heard a case involving 300,000 homeowners who are suing First Energy because they think they were cheated. I have said, I do say, and I will continue to say, it is wrong to take $44,000 from a litigant with an active case on your docket and rule on the case. That does not make them bad people. They're very good people. My name is Judge O'Neill. I think we should talk about issues.
And the issue of political funding will be a question that we'll ask later on here. So for Justices Cupp and O'Donnell, there's not necessarily a need to respond to that issue at this time. Better off just focusing on introducing yourself and your judicial philosophies. Justice Cupp, please.
Thank you. I'm Justice Bob Cupp, and I'm serving my first term on the Ohio Supreme Court. I bring a broad and varied experience to the work of the court, having served as a city prosecutor in Allen County, the city of Lima, served as an Allen County commissioner, 16 years in the Ohio Senate, including 4 years as the president pro tem, which is the second highest ranking leader in the Senate. 4 years on the Court of Appeals, and as I indicated, now finishing my first term on the Ohio Supreme Court. I think it is really important in terms of when people evaluate candidates for the judge and evaluate judicial decisions to think about the concept that is enshrined in both our national and our state constitution, which is that of the separation of powers. And that's not just a phrase, that is a concept which has real meaning in our constitutional system about the role of a judge in deciding cases. And my view is that while the role of a judge is an important one, it's also a limited one. Judges sit on the bench to decide disputed cases, to protect individual rights and to protect property rights, but they do not sit as a super legislature to rewrite the statute or revise the Constitution through strange or unusual or strained interpretations. We break down the barriers that are separating the different branches of our government and really restrain government from intruding upon individual liberty when judges or the legislature overstep their bounds. The difference between the legislature and the judicial branch, of course, is that under judicial review, the court has the final say on the power. So it's up to an individual judge, while they may have a power to go beyond the authority that's granted to them, to exercise restraint and decide cases simply according to the plain meaning of the statutes and the Constitution. And I think that's what best protects our system of ordered liberty.
And Justice O'Donnell, please.
Thank you very much, Maurice. Good afternoon, ladies and gentlemen. My name is Justice Terrence O'Donnell, and I am very proud to be here this afternoon and participate in what I think is an important forum about the upcoming election on November 6th. I'm particularly proud to be an elected member of the Ohio Supreme Court, and as I am here this afternoon, I'm serving in my 10th year as a member of the Ohio Supreme Court. My judicial career began as a law clerk in 1971 when I had the privilege of clerking for then Justice J.J.P. Corrigan while he was a member of the Ohio Supreme Court. I followed that clerkship by having the privilege of serving for Judge John V. Corrigan of the 8th District Court of Appeals and also for Judge John Manos, who later was appointed to the United States District Court and served there. My early training then was under the tutelage of jurists each of whom was widely respected in the state of Ohio. That developed for me a judicial philosophy and helped formulate in my mind the manner in which judges conduct their affairs and the manner by which they decide cases. I was privileged to have been elected to the Common Pleas Court in Cuyahoga County, and I served there for a period of 14 years, virtually trying every type of case in Cuyahoga County, which is the busiest trial court in the state of Ohio. I followed that 14-year period by serving on the 8th District Court of Appeals in Cuyahoga County, and I had the privilege of serving there for 8 additional years. And following that service then, I have been a member of the Supreme Court since 2003, and I bring to this office a period of 32 years of judicial experience. It's my view that as a cornerstone of judicial decision-making, we look to the doctrine of separation of powers. And that means that the legislative branch of government is the lawmaking branch, that the executive department is the department that enforces law, and the judicial role is to interpret laws and apply the law to a given set of facts. In every instance, judges must be open-minded, fair, willing to look at all sides of every issue, and approach the case with no preconceived ideas about outcomes. It is this philosophy, nothing new to me, something that I have developed through the tutelage of the jurists that I have alluded to and practiced in a 32-year judicial career. When we make decisions based on the law that is predictable to individuals and in accordance with law, by so much do we instill public confidence in the decisions rendered by our courts. Thank you very much.